Good afternoon, Chair Steele and members of the Indiana Senate Criminal Law and Sentencing Policy Committee. My name is Noah Mamber. I'm a legislative analyst for the Marijuana Policy Project, which works to reform marijuana laws across the country in states and federally. And thank you so much for having me. I'm here before you today to testify in support of changing Indiana's marijuana laws. The status quo is unworkable, ineffective, and immoral. Currently, possession of even one marijuana joint is a Class A misdemeanor under Indiana law, punishable by up to 1 year in jail and a fine of up to $5,000, with no exceptions for medical use by seriously ill patients. I urge you to carefully consider the actual harms caused by marijuana prohibition and to let your conclusions guide your recommendations for legislation in next year's session. I think you will find that the evidence shows that marijuana prohibition is much more harmful than actual marijuana use, and that there is no evidence that marijuana prohibition actually prohibits youths or adults from using marijuana. I'd like to start with a little history. Marijuana has actually not always been illegal. During the first century and a half of our republic, marijuana was used both recreationally and medicinally in America with great success. From 1850 to 1942, actually, the United States Pharmacopoeia, which has maintained a highly selective listing of the country's most widely accepted drugs, listed marijuana as a recognized medicine, and doctors prescribed it for various conditions including nausea and rheumatism. Eventually, after a campaign filled with racism and fear, assisted by William Randolph Hearst, as we talked about earlier, the federal government took action and Congress passed the Marijuana Tax Act of 1937, which effectively made it illegal to possess or transfer marijuana in the United States, against the opposition of the American Medical Association at the time. And the council actually came and spoke against it and advocated to not do that. In 1969, the Marijuana Tax Act was found to be unconstitutional because it mandated self-incrimination, and so Congress repealed it and passed the Controlled Substances Act in 1970, making a political and not a science-based decision and placing marijuana in Schedule I while creating clear criminal penalties for its possession and manufacture. Schedule I means that a substance has a high potential for abuse and no medical value. So after 74 years, it is clear, with evidence, that marijuana prohibition has been a complete failure, basically by any metric. Marijuana use is mainstream and widespread, and imposing criminal penalties has not reduced use and has created a huge illicit market. In 1937, relatively few Americans had heard of marijuana. Today, according to 2009 data, over 100 million Americans admit to having tried it, and over 80% of high school seniors say that it's easy to obtain. In 2008, the World Health Organization observed that in the Netherlands, where adults are allowed to purchase and possess small amounts of marijuana, that both teen and adult marijuana use is significantly lower than that of the U.S. Marijuana prohibition has also been a massive waste of taxpayer dollars and public resources, including law enforcement, judicial, and correctional time and money. Ending marijuana prohibition would result in billions of dollars in savings, and marijuana taxation would bring in much-needed revenues in these tough economic times. Marijuana prohibition also imprisons tens of thousands of people each year, ruining their lives and creating a criminal underclass of people who use or trade a substance that is less harmful than alcohol. Also, people of color are specifically targeted by marijuana enforcement, and the racial disparity is stark. Dr. John Getman estimated in a previous analysis that blacks are 20% of the U.S. population, but they comprise 40 to 45% of national marijuana arrests, even though they don't have higher rates of marijuana usage than whites. Marijuana offenders are also subject to very harsh collateral sanctions across the country after their convictions or arrests, including denial of eligibility to adopt, serve as foster parents, earn professional licenses, receive student loans or driver's license, and can even prevent otherwise law-abiding adults from being admitted to college or obtaining employment. Marijuana prohibition, like alcohol prohibition, also breeds substantial violence. Since only criminals may sell marijuana and disputes can't be solved lawfully, violence would be inevitable. According to Mexican government's data, since 2007, more than 34,000 people have been killed in drug cartel violence in Mexico. One more fact about marijuana prohibition. Marijuana, which is illegal, is safer than alcohol. Unlike legal substances such as water, alcohol, Tylenol, and prescription opiates, marijuana has never caused a single medically documented overdose death in recorded history. In comparison, alcohol causes over 300 overdose deaths a year, and in 2007, the CDC reported 23,199 alcohol-induced deaths and no marijuana deaths. And I have a lot of citations, obviously, in my written testimony, which you all have. While federal law has not progressed with the times, many state legislatures have taken another path and modified their marijuana laws after reviewing the evidence and listening to their constituents. This can happen because, as Mr. Abrahamson said, federal law need not be the same as state law, and they can coexist. From 1996 to 2007, 16 states, including neighboring Michigan and Washington, D.C., have passed effective laws that allow seriously ill patients state legal access to medical marijuana and protect them from criminal sanctions. This year, 15 other states considered effective medical marijuana legislation, including neighboring Illinois and Ohio, nearby Iowa and West Virginia, and conservative Mississippi and Idaho. The laws have evolved since 1996, and the states have learned from each other. The older laws were often ambiguous, and their implementation was more chaotic. But these newer, more nuanced laws have done a better job addressing community concerns while providing patients with protection and safe, consistent access. These new laws demonstrate a trend toward tightly regulated distribution and comprehensive civil and criminal protections. And they often have included an extensive competitive process for a limited number of licenses, whereby the state will evaluate a dispensary application's sufficiency based on a number of important criteria, including security and diversion prevention, suitability of locations and local input, board members' relevant professional experience, startup capital, record keeping, and a plan for making medical marijuana affordable for low-income patients. They also included provisions allowing for the creations of safety compliance centers to test the marijuana for contaminants, and they also often include extensive civil protections, including discrimination protection in employment, housing, education, child custody, and even organ transplants. After 15 years of medical marijuana laws and 29.2% of the U.S. population living in the 17 medical marijuana jurisdictions, we've had time to analyze the effects of a regulated medical marijuana system. And one of the critical points is teen marijuana use has generally not gone up after the passage of these laws. Of the 13 states with effective medical marijuana laws with before and after data on teen marijuana use, 10 reported overall decreases since the passage of the law, some of which were written within the margin of error. And no medical marijuana state has seen an overall increase in teen marijuana use outside the margin of error. And I'll repeat that. No medical marijuana state has seen an overall increase in teen marijuana use outside the margin of error. And again, included with my testimony is actually a copy of our teen use report that you can peruse at your leisure. Many states have also looked at how to reduce or eliminate penalties for low-level marijuana possession in order to save time and money. I believe replacing marijuana prohibition completely is the most sensible approach, but if you are interested in a more incremental change, please consider marijuana decriminalization, which means changing the criminal penalty for a modest amount of marijuana from possible jail time to a civil fine. If Indiana were to decriminalize marijuana, it would be in good company. 13 states, from Mississippi to Minnesota to Nebraska to neighboring Ohio, have done so. And this year alone, 10 states have considered these laws, including neighboring Illinois and conservative Texas and Tennessee, and one has enacted it. Further, in neighboring Kentucky, the legislature passed 38-0 in the Senate and 96-1 in the House, a sentencing reform bill that reduced penalties for possession of under 8 ounces of marijuana from up to a year in jail down to 45 days in jail. Decriminalization laws also save a significant amount of money in law enforcement resources. Dr. John Getman, in a 2009 analysis, estimated that Indiana would save at least $148.8 million if it ceased arresting and sending to jail low-level marijuana users. The current criminal penalty also forces law enforcement to spend valuable time on arresting, processing, and prosecuting nonviolent offenders, which would be better spent going after violent criminals. In 2006, the Indiana clearance rate for murder was 69%, and for rape, only 43%, both of which would likely increase if police officers could devote more time to their investigations. Finally, there is one more option that states are considering to try to harmonize their marijuana laws with common sense. Some states are seeking to remove all state penalties for adult marijuana possession, cultivation, and distribution, and replace them with a strict state-regulated distribution system. And given their budget crises, they have also entertained the idea of getting revenue from marijuana, which Indiana could use to fund education or lower property taxes, which I've heard is something you guys have been discussing here. This revenue, my organization, the Marijuana Policy Project, has created a model marijuana taxation and regulation bill that I helped draft and which has been introduced in 2 state legislatures and considered by their committees. It represents a good starting point that lays out what a tightly regulated system that includes licensed marijuana cultivation and distribution could look like. I'll outline it briefly, and we'll be happy to provide copies for anyone that would like. I have them here, or answer further questions about it later. Under our model bill system, possession and transportation of 1 ounce or less of marijuana would be legal for all persons 21 or older, while possession remains illegal for under 21-year-olds, mirroring alcohol laws. And it also creates a misdemeanor for trying to purchase marijuana with a fake ID. Legal marijuana consumers would purchase marijuana from retailers who would purchase prepackaged marijuana from wholesalers who would cultivate the marijuana. The model bill would allow for at least 1 retailer per county and at least 3 wholesalers in the state, which could be revised by the state's business regulatory agency to be as many as are needed to meet demand. Wholesalers and retailers would be chosen by the state, again, after an intensive competitive scoring process like the recent medical marijuana laws. And they also could not be within 500 feet of a school. Wholesalers would pay a $50 per ounce excise tax, while retailers would collect sales taxes on marijuana sales. The model bill also allows for the creation of safety compliance facilities to test marijuana for potency and contaminants. An adult over 21 years of age would also be allowed, if he or she chose, to cultivate up to 3 marijuana plants at home in an enclosed locked space as long as he or she did not sell it. The adult would have to pay $100 per plant to the state for a registry identification zip tie that would last for 1 year and that would be affixed to the plant, which basically is very much like hobbyist homebrewing. Driving while impaired and possessing marijuana at a detention facility or school would remain illegal, and public smoking would be banned. MPP's model bill has a lot in common with Indiana's alcohol laws. Indiana's alcohol laws also contain provisions that prevent access to minors, and they centralize the regulation and licensing of alcohol sales permits in one agency, the ATC. However, both laws also allow for some local control as well. In Indiana, beer must be manufactured by a brewer, sold to a wholesaler, who may then sell it either to a beer retailer or a beer dealer. MPP's model bill combines the wholesaler with the manufacturer, permits wholesalers to sell to each other, and allows the state to regulate whether retailers may allow on-premises consumption. Like MPP's model bill, Indiana law also regulates the time, place, and manner of alcohol sales, allows for advertising restrictions, and prohibits public intoxication. And the Indiana alcohol statute is actually less restrictive than MPP's model bill on the subject of home brewing, as it does not have a cap, as long as it is for personal use. Both MPP's model taxation and regulation bill and Indiana's alcohol laws attempt to rationally regulate the consumption of a product and demand by licensing appropriate individuals to distribute it in a limited fashion. In closing, I want to leave you with these thoughts. As you've heard from me and you will from others today, marijuana prohibition simply does not work. It is a colossal waste of public resources and human lives ruined by arrest and incarceration, all while marijuana use is as widespread and mainstream as it ever has been after 74 years. Ending prohibition will save billions and allow police to focus on investigating violent crimes instead. Here in Indiana, you can evaluate whether your marijuana laws are still achieving their objectives, and if not, you can make a change. You might think supporting marijuana policy reform is a dangerous political position to take, but that is actually a misconception. In addition to the enthusiastic response in favor of reform that Senator Talion received from her constituents, public opinion polls show that more and more people want to change these outdated laws and will not punish their legislators for doing the right thing on this issue, and even sometimes actually are driven to greater support for them. A 2010 ABC News Washington Post poll found that 81% of Americans support allowing seriously ill patients to use medical marijuana, including 85% of independents and 72% of Republicans. A 2010 Newsweek poll found that 55% of Americans support marijuana decriminalization, compared to only 41% opposed. And finally, while taxation and regulation does not yet have majority support, it will very soon. A 2010 Gallup poll found that a new high of 46% of Americans want to fully legalize marijuana, up from 25% in 1996. An impressive 61% of 18 to 29-year-olds supported this idea, demonstrating the likely inevitability of the change. Please, members of the committee, review the evidence and listen to the will of the people and be a part of that change. Thank you, Chair Steele, and members of the committee for your time and attention. Please feel free to contact me at any time if you have any questions or concerns.